and welcome. Thank you for joining us. My name is Carmen Rogers, and I'm one of the Associate Directors for Career Management within the School of Hotel Administration. And today I'm here with Hillary Fraser, who has been practicing immigration law with Miller Mayer since 1991, and she's going to be joining us to answer some questions with regard to H1B visas. So thank you, Hillary, for being with us today. So we're going to go ahead and get started. We have some questions that some students have been wanting to know the answers of. And the first question is what exactly is an H1B visa?
So an H1B visa is a temporary work visa for professional occupations in a specialty field.
Okay. And who's eligible to receive a H1B?
Typically, it's a person holding a 4-year degree, either from a foreign country or the United States, where that degree is in a particular field of study directly related to the job requirements.
And so is that all of the job requirements, or are there additional requirements that someone would have to have? And then if so, how many?
The individual doesn't necessarily need extra requirements. In fact, the degree requirement can be met through experience as well. That's more rare, but a person with a 2-year degree, for example, could have 6 years of experience in that particular field of work and still qualify by adding the 2-year degree together with the 6 years of experience. So the requirements for the foreign national are pretty much stop at the preparation, the undergraduate degree preparation. There are many requirements related to the process and the job.
Okay. And then also, what's the required wage?
So the required wage is one of the requirements the employer has to pay a required minimum wage to the foreign national. That required H-1B wage is the higher of what the employer actually pays to American workers in the same position at the same work site for the same job, or what the Department of Labor says is the appropriate wage to pay for that position in that location for that job. An important element of the wage requirement is that it be guaranteed. So the wage cannot be paid as a commission or a bonus or a performance increase for the employee, nor can it be paid as a part of the success of the company. For instance, shares in the company or options do not constitute proper H-1B salary.
So based on that, how do you demonstrate the employer-employee relationship?
So vertical employments typically work best for all temporary visa petitions and for green cards too. A vertical employment is a traditional salary by the hour or another period of time, week or year or month, job that is ongoing with an expectation of continuing or renewal.
And then how do you demonstrate that same relationship if the employer owns his or her own company?
So a contract is not required for an H-1B visa. The visa petition itself is the obligation and sponsorship of the employer for that employee. So a contract is not required. However, the petition itself has lots of elements and requirements that mimic what would ordinarily be in a contract.
Okay. What jobs qualify as a specialty occupation?
That is the increasingly important question in H-1B visas because the immigration agency has taken a very conservative view of what kind of jobs qualify. So having a requirement for a bachelor's degree in order to be prepared for the job is not enough. It has to be a bachelor's degree in a particular field of study. For example, the immigration agency takes the view that some jobs in sales or marketing or public relations or business or administrative jobs, no matter how high and how many executive duties a person may execute, is not necessarily H-1B eligible because any bachelor's degree may do. So a job in sales that requires a degree in marketing is an H-1B appropriate job. But, for example, a job in business that requires any type of bachelor's degree is not H-1B eligible.
So how do you prove the position is in an occupation that normally requires a degree in the related field?
That's another really important question. There are actually 4 ways. The first way is by reference to the Department of Labor's own indexes and reference materials that say this occupation requires a 4-year degree in this field. That's the best way to establish specialty occupation. After that, you can look to industry norms. So you can show that job vacancy ads, such on Monster or other employment websites, typically require a bachelor's degree in a specific field. After that, you can look to the employer's own hiring history. So if you don't have Department of Labor references that support, if you don't have industry norms that support, you can look to the employer's own hiring practices and say, this employer has a especially sophisticated job and has traditionally required a bachelor's degree in a certain field for this occupation. And finally, if you don't have that either, you can have a job description that's so complex and sophisticated that it necessarily requires a bachelor's degree.
So then how does a student with a particular degree, how does a student relate that to the specialty occupation?
Usually that's pretty easy, and maybe it's just a matter of explaining that at this particular school the degree is called information science, and at this school it's called engineering, and at this school it's called math, and at this school it's called physics, and at this school it's called computer science, but actually it's all the same degree in preparation. And sometimes providing the transcript and the coursework, or a letter from the school explaining the program, or a clip from the website of the school explaining the curriculum helps to explain to the immigration agency what the degree is about.
So then once a student is able to do that, then how do they demonstrate what the actual wage should be?
So that the wage obligation is actually a pledge made by the employer. So it's not demonstrated up front. Okay. Rather, it's a pledge the employer makes that it is paying the required wage. The student, for his or her part, may be asked to demonstrate after the H-1B is approved, when the student travels and encounters an immigration inspector at the airport, or when the student is interviewed at the U.S. consulate for a visa. At that point, the student may be asked to demonstrate that the student is receiving the required wage, and especially when a student changes jobs and needs to submit a second H-1B petition, then the student is going to be asked to show that in the first H-1B period of time, the student was maintaining status by receiving the proper wage.
Okay, good. That's great information. So on to some other questions with regard to visa number. So students would like to know, how do they go about getting an H-1B visa number?
Yeah, it's a challenge. So each year on April 1st, all of the private employers who are seeking H-1Bs for new employees file their petitions. And usually the demand for H-1Bs for private employment far outweighs the supply. So each year, in the first year of April, approximately 200,000 to 300,000 petitions are filed. Of those, only 85,000 will be selected for H-1B adjudication.
Okay. And so then how does a student then apply to start that process?
Right. So what does a student have to do? Well, first, it's always a good idea to get to know employers early and start the job hunt early. In fact, to have maybe interned or worked or done some conferences or meetings with the employer so that the employer is well acquainted with the student who needs sponsorship before April 1st. Second, the student has to have the degree by April 1st, of course. So for people who are finishing bachelor's degrees in May, for example, April before graduation is too early to apply for an H-1B. A graduate student, however, can still be in their program, in their graduate student program, but use their bachelor's degree as a premise for the H-1B application. After that, the student's job is mostly to work with the employer, and usually the employer's law firm, to put the H-1B materials together so that it can be timely filed.
Good. So other things, and you can actually help me understand this as well. So questions that students have are what exactly is DOL, CIS, and DOS? Can you explain that for all of us?
I think I can.
Okay.
So those are all the agencies, the federal government agencies under the umbrella of the Department of Homeland Security that are involved in the H-1B process.
Okay.
So the H-1B process is first a filing with DOL, which is the Department of Labor. And the Department of Labor's function here is to assess and audit the required wage and to ensure that there's no strike or lockout at the employer's workplace. After the DOL certifies its piece of the H-1B, which is called an LCA for Labor Certification Application, then the employer submits petition I-129 to CIS. CIS is the Citizenship and Immigration Service, formerly known as the INS, within the United States. CIS issues an approval notice. The approval notice is the student's document that says they have been accorded an extended period of stay, usually 3 years, in H-1B status. If the student chooses to leave the United States to travel internationally, then the student must appear at a U.S. consulate. U.S. consulates are under the umbrella of DOS, which is Department of State, in order to get a visa to re-enter the U.S.
You mentioned in a previous question or response the I-129, but if you don't mind going back, and could you maybe just explain exactly what that is?
Sure. That's a petition that's signed exclusively by the employer. So the student beneficiary, to whom the H-1B is very important, doesn't actually sign the I-129 at all. The student beneficiary merely provides supporting evidence, such as the degree. The I-129 is information provided by the employer about the company, the job, that it's profitable, that it's viable, about whether it employs other H-1Bs or L-1s, another type of temporary work visa, whether there are work stoppages or strikes or recent layoffs, and about the occupation, what the requirements of the occupation are.
And how does a student find out or prove prevailing versus actual wage?
Again, that is usually the jurisdiction of the employer, but students are best advised to be armed with good information about the process, including the wage, so that they can help their employer feel comfortable with sponsorship. Prevailing wage information is available through the Department of Labor online at a website called FLDC Wages. So a student can simply Google FLDC Wages and input the occupational title and location and come up with a hierarchy of wages for that position in that location.
So then, how long does it take to actually process this?
So the immigration agency, because they receive so many, all in the first week of April, takes months and months normally to process these first-time H-1B petitions. This year, for example, they took 7 or 8 months to process these applications. That's normal processing time. It can range anywhere from 3 to 4 months to 7 to 8 months. Processing time can be expedited by payment of a premium processing or rush fee. And any party, any person can pay that fee. It's not required that the employer pay the fee. Rush processing does not achieve a more favorable result, but it does deliver the news more quickly. So rush processing is typically 2 weeks. So from the time that the immigration agency receives the premium processing fee, it promises a decision in 15 working days.
Okay. So now, going on to more information just with regard to travel. So questions that students sometimes have. So what does a student need to do if they travel outside of the U.S.?
So an H-1B employee who travels outside of the U.S., so long as they only travel within North America, doesn't really need to do anything except get a pay stub and a letter from their H-1B employer saying they are continuing in the job. So with the petition approval, a pay stub, and a letter, that H-1B employee can travel to Mexico or Canada for 30 days or less and be readmitted without getting a visa. For travel outside of North America, or lengthier periods of travel inside North America, an H-1B employee needs to be screened for readmission. And that screening happens at a U.S. consulate, and a successful screening results in issuance of a visa. And a visa is a stamp in a passport that is essentially a key to get back into the United States. Different foreign countries have visa durations that vary in length. For example, Chinese H-1Bs are only 1 year in length. So a Chinese H-1B employee who has a 3-year petition approval but has to travel internationally very frequently for work, for example, may need to make 3 subsequent visits to the U.S. consulate to refresh that visa.
So is there a way that students can have that visa extended?
Oh yes, as long as the petition approval is still valid, the visa can be renewed or refreshed. It actually can't be extended from within the United States, but it can be renewed.
Okay. So then what happens if the student changes jobs or changes employers?
That's fine. Truly the most difficult part of the H1B is the first time H application. It is qualifying for one of those precious 85,000 visas in the first April. Once that first H1B is secured, then changing jobs requires of the new employer to file a whole new petition all over again. But there's no supply limit. That employee has already been counted against the quota and carries with him or her the quota, the H-1B quota number for the rest of their H career. The new employer files a new H-1B petition, and the employee can start work the day after the second employer files. So that long adjudication period of perhaps 7 or 8 months really is irrelevant on the second go-round because the employee can join the new employer immediately.
Now, is there a cost associated with this?
There is. H-1Bs in general, each transaction can cost between $5,000 and $6,000. That's because the filing fees range from $825 to about $3,500. Depending on whether it's a private company or a university, whether it's a small entity or a large entity, and whether it's the first time H-1B or a subsequent renewal or extension. Those are the filing fees paid to the government. Of those, the $1,225 premium processing or rush fee is entirely optional. Legal fees for this kind of transaction are generally about $3,000. So altogether, a budget of about $5,000 or $6,000 per H-1B transaction.
And so, if you mind just clarifying, so who's actually paying those fees? Is that the employer or is that the actual student?
That's another really good question. So the employer is required to pay one of those fees. A smaller company is required to pay $750, and a company with 25 or more employees is required to pay $1,500. The remainder of the fees, including the legal fees, can be borne by the foreign national prospective employee, so long as recoupment, if the employer is asking the employee to pay back the employer for certain expenses, don't lower the required H-1B wage below the required threshold.
And then one last question related to that is what exactly is CAP exempt?
So CAP exempt means essentially a university-sponsored H-1B job. So the lottery, the April timing, the 85,000 supply of H-1B visas we've been talking about pertains to CAP subject employers. And CAP subject employers are neither universities nor government research entities. So when we talk about CAP exempt, then we're returning to the world of universities and their affiliates or government research employees. And universities is defined rather broadly to include, for example, all the affiliated research institutions, teaching hospitals, some private-public consortiums that exist in a campus environment.
Okay. So next question here is, there's something important that happens in October. So the question is, what is important about the October start date?
Yeah, good question. So April is the earliest that an employer can seek H-1B approval. But if the employer is successful in securing an H-1B approval in the April race or lottery, that approval is effective October 1st. So the petitions are all filed the first week in April. They can be approved as early as May if someone has paid the premium fee. They might not be approved until September without the premium fee, but all of them will be effective for the first time on October 1st. And that's because October 1st is the same as January 1st for the federal government. It's the first day of the federal government year.
Okay. And I think you mentioned this in one of your responses to a previous question, but the question actually is, what is cap race? And can you just maybe talk a little bit about what that is?
Sure. So the cap race started in 2006. Before that, there was a much bigger supply of H-1B visas, so private employers could apply anytime during the year. Once the supply shrank, there became what's known as the cap race, or the lottery, which was a large number of employers competing to get that very precious small supply of H-1Bs. Therefore, employers, again, file as early as possible. They file on April 1st, which is the earliest date they can file. And they all tend to file at once, knowing that the supply will be exhausted quickly. In some years, the entire annual supply of H-1B visas has been exhausted in a couple of hours or one day. Now the immigration agency has what's called the lottery, which all that means is they will accept applications for a full 5 business days, so that mail interruptions, FedEx interruptions, weather interruptions don't prejudice any filers. They keep the filing window open for 5 days, and usually they receive 200,000 to 300,000 petitions. And then without opening the petitions, they randomly select a certain number of them. And those are selected for adjudication. So just being selected doesn't mean you're going to be approved for an H-1B. Approval rates are fairly high, perhaps 85 to 99%, but being selected means you get a receipt for your petition and you know it's been selected for adjudication.
Okay. And you said exactly how long this entire process is. How long does it take?
Well, beneficiaries will start to know whether or not they've been selected in the lottery, whether or not they have a receipt for an H-1B about May 1st to June 1st.
Okay. The next question here is there self-sponsorship?
No.
Okay.
There is not. A foreign national who seeks an H-1B cannot sponsor him or herself. An entity that is partially owned by a foreign national can sponsor that foreign national as an employee, so long as there's disclosure of that fact and the foreign national beneficiary of the H-1B petition is not a controlling owner of the company.
And can a student make more than $65,000 a year?
Oh, yes.
Okay.
Yes.
Other questions related to salary. What's the impact of having a master's degree or some other higher degree?
Having a U.S. master's degree from a public or not-for-profit school, not a for-profit school, is very beneficial because it improves one's chances of securing an H-1B. So there are actually 2 lotteries that happen concurrently. The first lottery is 20,000 H-1Bs are set aside for applicants who hold U.S. master's degrees. Usually about 70,000 applications go into that pool, and they are first randomly selected. Those not selected are then put into the bachelor's degree pool. So having a U.S. master's degree gives a person 2 chances at the H-1B lottery.
Are there any other H-1B cap exemptions?
Functionally, there are. So we mentioned that universities and their not-for-profit affiliates and government research institutions as employers are cap exempt. However, there are 3 kinds of cap exemptions that are functional. One is, of course, an individual who has already secured a quota or cap H-1B number is cap exempt for the rest of their H-1B time. Second, someone who has a part-time second job at a private company can be treated as cap exempt, where the first job is through a university. For example, if someone has a part-time H-1B to work 10 hours a week in the computer science department at Cornell, and then finds private employment additionally, that private employer's H-1B petition rides on or piggybacks on the university cap exemption and is treated as cap exempt. In a slightly more rare example, there's a cap exemption for being employed at a university, even if the employer sponsor is a private company. For example, if Microsoft employed an individual to do research on campus for Microsoft, but on campus at Cornell, that H-1B petition could be treated as cap exempt. Increasingly, as people are not successful at the initial H-1B lottery, they think about these kinds of cap exempt options.
So what does it mean when a student understands that you can move from being exempt to cap subject employer? What exactly does that mean?
It's a caution to a student who starts out in an academic environment, and then after a year or two working as an H-1B, that's a cap exempt H-1B, wants to move to a private job. It's a reminder to that student that they too, even though they have an H-1B, it's not the right kind of H-1B. It's a cap-exempt H-1B. Therefore, they still have to participate in this April lottery. So the timing for moving from a cap-exempt university job to a private job is still April 1st.
So then why is that important?
Because the supply of H-1Bs for private industry is still very small. And having an H-1B for a university does not secure you a private cap H-1B.
So then what is a cap gap extension?
So that's an important policy memo put out by the immigration agency that it provides a benefit to graduating students. So graduating students get work permits. Typically those work permits are about 12 months in duration. It's called OPT. Those work permits typically expire in the summer. Graduation is usually in May, and the work permit being 12 months might run June to June or July to July. This could be inconvenient to students who are successful in securing an H-1B, but it doesn't start until October. So these students might work for an employer for 12 months, then be faced with having to depart for 3 months and return on October 1st. To solve this problem, the immigration agency has a policy called cap gap that says if on April 1st a student's work permit is valid, they're still within their OPT, and an H-1B petition is submitted in the cap lottery, and it is selected, it is received, and ultimately approved, then that individual's work permit is extended by matter of law until September 30th so that they can continue their employment without interruption.
And so during this time period, can a student travel?
It's actually not a good idea at present. Under current rules, it's not a good idea, and here's why. First, if there's a change of status petition pending, so from F student to H-1B is a change of status. If that petition has not been approved yet, so say between April 1st and July 1st or even later, that petition is still pending. Departing from the United States cancels the change of status request. That will mean effectively the student loses cap gap protection. So cap gap protection, that extension of work authorization, is only valid so long as the student remains in the United States and continues to work. Second, if the petition is approved, say a student has paid the premium processing fee, and they know that they are going to get an H-1B visa effective October 1st, well, maybe under some conditions they might be able to travel and be readmitted as an F because they have a visa, a work permit, their I-20 is valid, and they have a job with a letter. However, F students require an intent to return home to their country at the end of their OPT, which is almost over. So they're asking to be admitted at the very end of their OPT back to the United States and having already established that they intend to stay and work on an H-1B. So it's really not a great idea to travel during the summer in that transition between F and H.
What is ITAR, Export Control Attestation?
ITAR is a question that every employer has to answer on the H-1B petition, although it pertains to very few jobs and people. ITAR is an export license required when a sensitive technology is disclosed to a country or a national of a country that the United States has security concerns with. So ITAR is a new piece of the H-1B, and we've only seen it be relevant in a handful of cases, such as PhDs in chemistry who are perhaps going to work for a government contracting kind of company might have an ITAR license requirement. Most H-1Bs do not.
What kind of H-1B enforcement exists?
H-1Bs are very topical in the U.S. and are focused on very seriously by Congress, so there is a substantial amount of enforcement of H-1B compliance, and that happens through worksite visits to the employer's place of work, asking to interview the H-1B employee. And the inspector may come from the Department of Labor or from the Government Accounting Office or from DHS or the immigration agency, and they ask the H-1B employee questions about what work they're doing, what their salary is, and whether they are complying with the terms of the H-1B petition.
Now, how does a student improve his or her chances of securing an H-1B in the April lottery?
Yeah, that's a really important thing for students to focus on. So one is plan ahead, prepare. Attend all of the job and career counseling forums you can, go to job fairs, get to know employers. Perhaps you want to consider curricular practical training or a summer job or an internship, and be realistic about the visa options that exist in the United States and your own skills and education. So for example, if you are a hospitality manager, you probably don't want to be looking at jobs teaching at a private school. That's not going to make your visa petitions very successful.
What about alternatives and backup plans? What other things should students be concerned about?
Students should definitely have alternatives and backup plans and take a long-range view of the April lottery. Most students will have more than one chance at the April H-1B lottery because their OPT may be extended. They may go back to school and get a second round of OPT. They may have the STEM extension that would allow them 2 or 3 chances at the April lottery. If at the end of the day a private company H-1B is still not a successful option for the student, there are other options. There are treaty investor visas called E-2s, where a student can invest in his or her own company in the United States and gain a visa. Taking the U.S. degree overseas and working in the home country for a 12-month period as an executive or manager, and then being transferred back into the U.S. affiliated branch is a very good visa option known as an L1. There are also O1 visas for people with special portfolios or resumes that show achievements in the field.
So if a student does get an H-1B and wants to go back to an F1, is that a future option for them?
It is, and it's increasingly common that undergraduate students may join the work world for a couple of years and then return to school and want their F1 status back. It's good to remember that F1 visa status requires an intent to return to the home country, and having worked for many years in the United States may defeat that intention, may defeat that showing, unless the student can show that the particular degree they're pursuing really provides great career options in the home country. Maybe they work at home for the summer leading up to that graduate degree start date. But it is very possible to return to F1 status after having H-1B.
And so we have one last question with regard to H-1B, and it's probably the question that students really want to know the most. Do you need a lawyer throughout this process?
I think it's always a good idea for a student to get a consultation on the student's own options and alternatives and concerns, because a student should remember that the H-1B is filed by the petitioner, and a law firm who is generally involved is really the employer's lawyer. Some companies are generous about sharing that lawyer representative with the student and providing some guidance to the student, but some bigger corporations with more restrictive policies will not talk to the student, will only advise the employer. So I think a consultation is a good idea. A student who's joining a smaller company that perhaps hasn't done an H-1B filing before, or doesn't have a standing law firm to advise the employer should also definitely advise the employer to secure a law firm. This is not the kind of petition that a company wants to undertake on its own.
And that's great information. That's the last question that I have. I certainly want to thank you for taking time out of your day to help us to better understand the H-1B visas. Thank you very much, Hillary. We really appreciate all of your time.